Please be seated. Good morning. This is the time set for oral argument in 1 CACV 170605, Jones et al. Versus Denning et al. Good morning, counsel. I'll let you know that we've read the briefs. We've conferenced the case this morning, so please keep that in mind when you make your arguments. For all in the courtroom, for our benefit, please, if you have cell phones, please turn them off or on vibrate. And counsel, we are recording these proceedings, and they'll be posted to YouTube at a later date, so if you would please state your name and the party you represent before you start your argument. To Mr. Abney, you'll obviously be able to save some time for rebuttal. We just ask that you keep track of that on the clock and the podium. So with that, Mr. Abney, go ahead.
May it please the court, my name is David Abney. I'm here representing Catherine and Alan Jones, who were able to come today and be with us. I had a major surgery recently, and I have more of appreciation of what my client has been going through in a very minor way. And I also took my last pain pill today, so I should be ready to go and be able to stand without any problem. The three issues we brought up in the opening brief were specific personal jurisdiction, claim preclusion as far as Medtronic, and a community property issue concerning Dr. Judith Kirby. The last two issues I think were briefed pretty thoroughly, and I don't intend to spend much time on that unless the court wants me to go into those issues. We also sort of rebriefed the Medtronic thing in light of what happened at the United States Court of Appeals for the Ninth Circuit. But for specific personal jurisdiction, we have a very interesting case with the defendants reached from Texas into Arizona, and in response to two specific questions that have been given to them, the use of cadaver...
They reached into Arizona, but then you followed up with saying in response. Didn't they just respond to inquiries from your client?
They did, and they could have responded truthfully and honestly, and they didn't. They lied for both of the answers to the questions, and they did that from Texas into Arizona. So that is a purposeful contact. Whether it was response to something that was sent to them, I don't think that matters for a specific personal jurisdiction inquiry. What matters is that the contact came from Texas into Arizona, and based upon those two answers, which both involved the donor bone issue, then Catherine and Alan agreed, well, we'll go to Texas and have these procedures. There were a number of misrepresentations that were made about the procedures, so the procedures were not done under informed consent of any kind. It turned out they were investigational, experimental procedures. They were procedures that she did not consent to in any way. But the trigger for all of this, the thing that kicks it off, is them sending a communication into Arizona to an Arizona resident saying falsehoods. That there was enough, that I think it was, would there be enough of my own bone recovered so that to use for the future?
If your client had called them in Texas and they'd answered the phone, would that be enough?
It might be if, you might have some evidence problems there, maybe not, but yes, it would be enough if they responded back, because they are coming into Arizona in a sense, at least in a...
I'm separating it from, let's say, they called and left a message and they called back. That would be one fact scenario. But just they call the phone and someone answers the phone on the other line, and she says, hey, I'm calling from Arizona, so there's no knowledge issue right away.
Right.
Would that be sufficient?
Well, it depends what's said from Texas to Arizona.
Why does what's said matter?
Well, if you just answer the phone in Texas and say, hello, Arizona, how are you doing? So what? But if you call from Texas and say, in response to your specific questions about the donor bone issue, no, you don't. We're not going to use the donor bone, and yes, you've got plenty. We'll harvest enough from you. Everything's going to be fine.
That's more of a merits analysis than a jurisdiction analysis, isn't it?
No, it's a substance of the communications analysis. What is the communication that's been made?
If they answered truthfully, wouldn't that be the same analysis then?
If they
accepting your allegations that they lied when they responded in these emails.
If they answered truthfully, we wouldn't be here.
Right, but would you have jurisdiction?
If I could come up with a cause of action for somebody telling the truth, I suppose. But I have a hard time with that one. But the point is that something important came into Arizona, not just an exchange of pleasantries or typical telephone courtesies. Something very important was said to Arizona, which was the trigger for Catherine going to Texas to be the victim of the medical battery. And it was a trigger for everything else that's happened to her since then. I mean, the cascade of medical problems that she has had is truly horrific, resulting from these events. Which, of course, is, and I may say as an aside, you probably looked over the complaint. It's a very big complaint. It's passionate. It's filled with a lot of facts. It's a little bit repetitive. It's not organized as well as a lawyer would have done it, although there is a solid organization there.
Some lawyers probably wouldn't have done much better.
Well, thank you, Your Honor. I think you're right.
Not you.
Present company excluded, of course.
But things like the paragraph numbering, because what happened was the word processing system let them down. It refused to number paragraphs. So, but considering all of the things that she has been through and he has been through, it's really quite a very good production, all things considered. And I ask the court's lenience in looking at it. There is a lot of information there to put these defendants on notice as to what they did wrong. Now, you may say to yourself, this reads sort of like a Hollywood script. How could anybody do these things so badly and with such intent, with such a collaborative, conspiratorial, collusive effort? Well, at this point, the things that are said in the complaint need to be believed because this was knocked out on motions to dismiss. You need to take them and say, okay, let's assume they're true. Is there enough there? Not only to establish a personal jurisdiction, but also, to look forward a little bit. Is there something worth going forward on? Which is always, I think, always in the background of every lawyer's and judge's minds when you look at a complaint. Okay, technically they allege something, but is there really something of substance there that we should go forward on? And there is a great deal of substance. The basic thrust of what they alleged was a purposeful direction, which led us back to the initial point here about communications made from Texas to Arizona that started this whole thing off. Walden case is I think I got the name right. Yeah, the Walden case is pretty interesting. It's sort of in a negative way. It talks about all the things you need to have specific personal jurisdiction, which weren't really there in the Walden case. It involved that search and seizure at the Atlanta airport, but there wasn't anything that ever was directed into Nevada to Nevada residents, things that affected them but not directed at them. So I think that case, if you take a look at the language there, it's actually a pretty helpful roadmap on what needs to be done. I can go on forever, but I think I've made my initial point, and I'd like, since I've got 5 sets of people who might be talking after me, I'd like to reserve my time.
You talked just about one issue, though, and I would like to hear you explain a little bit on the how we should resolve or how we should handle the res judicata issue with respect to Medtronics now going forward. So, what is your best case scenario for what we should be doing as a court?
Best case scenario would be to say that the U.S. District Court judgment is gone, and that it's going to come back to the U.S. District Judge, and they're going to, at that point, it's going to be dealt with in the federal forum for the issues that are in that complaint, the product liability, basically, kind of issues. Now, I didn't really hear it from the other side too well. If I did hear it, I didn't understand it. I don't think they've ever come forward and say, well, this is splitting the causes of action kind of problem. And they could have and could have raised that earlier, and they didn't. I think that's been waived. I think
for us, but it's not. Are you arguing it would be waived if they tried to re-urge it in the Superior Court on remand?
Well, we'll find out. I don't think they raised it at the Superior Court, but if and it may be waived. I think it's waived at the Superior Court too at this point. That they let this case go forward in the Superior Court long enough and let the District Court case go forward long enough that now they can't say, well, it's all one case, it has to be combined or everybody gets thrown out the window.
I don't think that's before us. So anyways, yes, that would be an issue you'd have to take up.
I'm thankful that it's not before you.
But didn't Medtronics raise other arguments in their motion to dismiss,
i.e.
lack of personal jurisdiction, failure to state a claim?
It did. And I think that
are those properly before us? Those arguments.
I'd like to say no.
I mean, but aren't we obligated to affirm the trial court if it's correct for any reason?
I'd like to say you're not, but I think you are, honestly. But I briefed all those issues anyway in the opening brief. I dealt with those. Personal jurisdiction, they are part of this group that was responsible for what happened, the medical battery, the misrepresentations, the investigational experimental procedures. In fact, there were Medtronic representatives in the operating arenas while all this was going on. So they had a hand in all of these things, and I think they would be subject to personal jurisdiction under the same basis as the Dallas Neuro defendants and the other defendants. As far as the other issues, I briefed those pretty well, and I'll stand by the briefing. May I reserve my time? Or I'd be happy to answer more questions.
Questions?
Yeah.
All right, thank you, Mr.
Thank you,
Chairman.
gentlemen. Your Honors, sorry.
The appellees, I don't know how many are going to argue, but you have 20 minutes to divide as you see fit. So with that, counsel, go ahead.
Good morning, and may it please the court. I'm John Barnes here for Dr. Denning and the Dallas Neuro defendants. I'm sharing my time with the other defendants, so I only have a few minutes to address the court, and I'd like to use that time to answer your questions, if there are any. Otherwise, I'll yield my time to the other defendants.
Well, I'd like you to respond to what appellant's counsel just argued with respect to the email and the purposeful availment. So I've read your brief, obviously, but why isn't it relevant to us that you guys had this at least one and maybe more extensive email communications about what would be going on?
Well, we're talking about emails that the Joneses sent from Arizona to Texas, and Dallas Neuro responded to, and it's black letter law that the plaintiffs cannot, through their own unilateral activity of sending communications or questions from the forum state, create personal jurisdiction over an out-of-state defendant.
You're saying even if there was 20 subsequent emails or conversations that occurred as a result of the initial email, it sounds like you're not suggesting that would be forever bar them from establishing personal jurisdiction. Are you?
Well, but that's not what we have here.
Well, true, but I mean, where do you draw the line? Two emails is not enough, too responsive, but with 3 or 4 or 5?
The cases talk about actively pursuing a contact in the forum state.
Did your client want these people, the business?
Which cases say actively pursuing, by the way?
Planning group, the GT helicopters case is right on point. It talks about merely responding to communications from the forum state isn't actively pursuing or directing the contacts into the forum state.
By responding to the email, what was the purpose of responding to the email if your clients didn't want to actively pursue having them as a client?
Well, look, there
patient.
already is a doctor-patient relationship. This came after the Joneses traveled to Texas and met with Dr. Denning, followed his order to get some diagnostic testing done, went back to his office. I mean, there were half a dozen or more interactions before this in Texas. And I don't think this court wants to promote a policy where a doctor has to withhold responding to a patient's inquiry until he can verify from where that patient is sending the communication or the question. Cases across the country, including in the Ninth Circuit, have roundly rejected the idea that a doctor becomes subject to personal jurisdiction in every state where his patients might carry potential claims against him based on his services. Did that answer your question, Judge? Okay. Are there any other questions? Because I'm almost out of my time here. If there's anything y'all want to talk about, I would love to answer some more questions. Otherwise, I'll respectfully ask you to affirm.
Thank you, Mr. Barnes.
If it pleases the court, my name is Jeffrey McLaren. I represent the Texas Health Resources defendants. I join in everything Mr. Barnes just said. The only other thing I would add is that my clients did not initiate any contacts with plaintiffs. Plaintiffs appellants first came to us via Dr. Denning's referral in Texas. They first appeared at the Texas Health Resources Hospital for a myelogram in Texas. We did not reach out, or my clients did not reach out at all to initiate any contact in Arizona. They merely responded to certain communications. In fact, one of my clients, Ms. Sims, is an operating room nurse. The only allegation against her is she got the informed consent signed in the operating room before the procedure. She certainly had no communications into Texas. The only way, into Arizona, I apologize. Thank you. The only way plaintiff or appellates try to get jurisdiction over us is via a joint venture theory that was not pled below. And to the extent that's even applicable now, the mere allegation of a joint venture should not overcome a factual requirement to show personal jurisdiction in the trial court. Merely alleging a joint venture, if that were enough to overcome affidavits showing there is no jurisdiction, as there are by all the appellees in this case, then jurisdiction means nothing if a mere allegation in a complaint of a joint venture or a conspiracy is enough to overcome actual admissible facts. Does the court have any questions for me?
No, I don't. Thank you, Mr.
Thank you.
McLaren.
May it please the court and counsel. I'm Dina Anagnopoulos. I represent Dr. Randall Kirby. I will only be arguing on his behalf as there's another attorney here that represents Judith Kirby. We stand by our briefing, and the only thing that I would like to add is in the Joneses' appellate brief, they are now trying to lump everybody together and argue that this group of defendants availed themselves to jurisdiction in Arizona based on their contacts. However, it has been undisputed in the trial court that Dr. Randall Kirby had absolutely no contact with the forum state. He had absolutely no communications with the Joneses while they were here in Arizona. And in fact, the only time they ever learned of Dr. Kirby was when they received an email from, I believe, Dr. Denning's office stating that Dr. Kirby would be assisting in one of the procedures. There is absolutely no contact with Dr. Kirby in Arizona. He never made any communications in Arizona. And it is not until the, yes, I'm sorry.
Your client brought in under this joint venture theory.
Yes.
I believe, Mr. McLaren.
Correct. And that is the first time we've actually heard of this joint venture theory, and it was never raised in the trial court. The appellants are actually trying to argue now that this was addressed in the Joneses' response to Dr. Kirby's motion to dismiss. However, they point out one sentence in the response to the motion to dismiss where the Joneses claim that he was part of a fraud. However, that is a separate claim in this case. They filed a 144-page second amended complaint with specific claims, and Dr. Kirby cannot be expected to go through this 144-page second amended complaint to determine what in essence was claimed. There was never a joint venture or joint enterprise that was claimed until now, until this appeal.
Would it be, let's say we find a way around the waiver issue or the failure to raise it below, would the joint venture theory have any merit to it?
No, I don't think it would, as this was never included in the complaint. This was, there's no indication these elements have not been claimed. There are specific elements when it comes to a joint venture, a contract between the parties, that they were sharing in the profits. Nothing like that has ever been claimed. Dr. Kirby, as was set forth in the trial court, was asked to assist in a surgery as a vascular surgeon. I don't want to get into all the little nuances of this surgical procedure and what he was asked to do, but there is no basis for this joint venture claim, as they have not alleged the specific elements. If we have any other questions, I will go ahead and stand by my briefing.
All right. Thank you, counsel.
May it please the court, my name is John Quinn, and I am here on behalf of Dr. Judith Kirby, Dr. Randall Kirby's wife. I believe on the particular issues in regards to Ms. Kirby, our briefing, I believe adequately addresses those issues. So unless this panel or your honors have any questions for me, we intend to stand by our briefing on the community property and specific jurisdiction issues.
All right. Thank you, counsel.
May it please the court, Kenneth King on behalf of specially appearing defendant Medtronic PLC. In my argument today, I wanted to address 2 points, subject, of course, to any questions the court might have. First, the plaintiffs lack personal jurisdiction over Medtronic PLC under the Supreme Court's holding in Daimler and Bristol-Myers Squibb. Second, even if plaintiffs were to surmount their lack...
And I'm sorry to interrupt you, but I'm wearing the robe, so I get to do rude things. As I read the record, and I read the Superior Court's ruling, it did not grant dismissal on personal jurisdiction grounds as to Medtronics. It was solely based upon the res judicata argument. Why would we want to reach that now?
Because under the court's de novo review, you can. And two, there is absolutely no factual basis in the complaint and in this record, to assert personal jurisdiction over the Irish holding company. Absolutely none. And their joint venture theory lacks any factual basis as to any possible joint venture as between Medtronic PLC on one hand and the physicians on the other. There's just nothing in this complaint, nothing in the record. In fact, in the record, there is an affidavit on the motion to dismiss below, a company affidavit, which describes the principal places of business and places of incorporation of all the relevant entities. That's not in dispute here. So
this may be outside the record, and feel free to just decline to respond on that basis if you want. But just looking at case law that's out there right now, we have a district court, Arizona federal district court case that you guys are participating in. I assume that meant there's personal jurisdiction in the District of Arizona.
Can I correct you?
Let me finish.
Sorry.
And I also know that you guys have an appeal pending, I believe, that's before the Arizona Supreme Court now, so there's likely jurisdiction there as well. Why is this case different from those?
Because they sued the holding company. The holding company was not, for example, the Irish holding company was not sued in the case that the Ninth Circuit just heard. Nor was it sued in I believe, and I'm not involved in the Conklin case, which is, I believe, what you're referring to, that the Supreme Court just argued in early October. I think the holding company was sued there. I know for a fact it was not sued in the case the Ninth Circuit just heard. So they've sued the Irish holding company, no dispute. The Irish holding company is incorporated, is an Irish company with its principal place of business in Dublin, not disputed. Therefore, under Daimler, there can be no general jurisdiction, nor can there be specific jurisdiction under Bristol-Myers Squibb. The surgeries occurred in Dallas, Texas. And what they're left with is a joint venture theory which has no factual basis in the complaint, putting aside the waiver issue, has no factual basis in the complaint as between the surgeons on one hand and Medtronic PLC on the other. So I do believe upon this court's de novo review, you can affirm the dismissal of this case, albeit that the dismissal below was on res judicata grounds.
Counsel, I'm just confused a little bit because in your supplemental briefing, you said you agreed that res judicata was no longer on the table as a result of the Ninth Circuit's decision, but then you asserted two alternative grounds to uphold the dismissal. One, collateral estoppel, and two, failure to state a claim. Correct. But I don't see personal jurisdiction. Why not re-urge that in the supplemental briefing? Because I read that as perhaps you're taking that off the table.
Not at all. No. I drafted the supplemental briefing, of course, and what I read the supplemental briefing to ask about was what would happen to the res judicata issue. And that was the only issue we sought to address. We didn't want to reiterate the jurisdictional arguments because we felt that was not what the court was asking about. Would have been happy to use that as a means to issue a surreply, but I chose not to because I thought that would be out of bounds.
But you would agree that collateral estoppel, at least, would you agree with me that you did not raise that in your motion to dismiss in the Superior Court? Collateral estoppel, or did you argue res judicata and collateral estoppel?
We argued res judicata because that was all. We felt that took into account everything. Okay. Clearly, they're collaterally estopped on the fraud claims, which, as we stated in our supplemental brief, not only did the Ninth Circuit have before it the federal complaint, but it took judicial notice of this complaint as well. So the Ninth Circuit decision said they found no reliance on any misrepresentations, so including the representations of the complaint they took judicial notice of, which was this one. Had the Ninth Circuit found any plausible fraud allegations, I could state with near certainty that Judge Hurwitz and the rest of the panel would have given her leave to replead.
Hopefully you'll agree with me, or you'll tell me that I'm wrong. But those are inherently factual findings that we're not in a good position to review. Aren't those issues, since you didn't raise the claim preclusion argument below, it's something that needs to be addressed in the first instance by the Superior Court, if it's sent back?
I don't think so, because what the Ninth Circuit did was very clear. The Ninth Circuit, it is not disputed that they took judicial notice of this complaint. It is not disputed that, having done that and evaluated the fraud claims in the federal complaint, they said that affirmed the dismissal of the fraud claims without leave to replead. Therefore, she's, under the rules of collateral estoppel, she's stopped here. They had a full, looking at the requisites of collateral estoppel, they had a full and fair opportunity to litigate the issue. It was rigorously litigated. A bulk of the argument in the Ninth Circuit was on this very issue. I know I was the arguer. It was material to the court's decision. All of the requisites of collateral estoppel are met here. I don't think there's a reason to upon this court's de novo review, send it back down when the requisites of collateral estoppel are fulfilled. As I mentioned, there is no general jurisdiction here under Daimler. Daimler at page 760, 134 Supreme Court 760 uses the example whereby the jurisdiction was sought over the parent in Daimler via its subsidiary, and despite the subsidiary's extensive contacts in California, even the court said even if those contacts were imputed to the parent, that still would not provide general jurisdiction here. There's no specific jurisdiction because the events took place in Texas. That leaves the joint venture theory, and as I said, there's absolutely no basis, putting aside the waiver issue, no basis to assert any joint venture between the device company, any Medtronic entity, and the surgeons here. They found no case either where a device company or a pharmaceutical company was found to have jurisdiction over it based upon a joint venture with the surgeons who used the device. I do want to address the battery claim, because the battery claim is...
While you bring that up, the claim preclusion that you argued earlier, or collateral estoppel, I guess I should say, as the fraud claim wouldn't apply to the battery claims. So we're going to, if we send something back, if we decide res judicata no more, unless we decide personal jurisdiction is a basis for dismissal independent, there's something going back to the Superior Court, right?
I don't think so, for two reasons. The first reason, it's unclear what they're claiming against Medtronic. How these fraud and battery allegations are tethered to Medtronic is not necessarily clear. At times, reading the complaint, it's as if the fraud precipitated the battery. So to the extent that's the case, we argue that they are stopped on fraud in that context. But on the battery claim, there is, if you look at the complaint, there's absolutely no basis for it. What they're alleging is that a Medtronic clinical specialist acted as a substitute surgeon. That's at page 24 of the complaint, line 5. That's an information and belief allegation based upon an internet job posting, a generic internet job posting, not part of the medical records, 4 years after the fact. That's Exhibit 22 to the complaint at the next page, page 25. This is an unusual complaint. She attaches her medical records to it. Her medical records refute the baseless allegation that Dr. Denning needed a substitute surgeon to perform the surgery. The operative reports, it's Exhibit 13, 14, 15, and 16 of the complaint, don't indicate any substitute surgeon was in the room performing substitute surgery. Those are part of her allegations. They refute any participation of Medtronic doing the surgery here. Not only that, there are other records which indicate, which she has attached, which indicate Dr. Denning's significant experience with the product, with the device. At Exhibit 54, 5 years after the surgery, he wrote her a letter which state that he had, at the time of the letter 2012, 7 previous years of experience with the device, all without complications. At the time of the surgery, that would have been 5 years of experience. He did not need any substitute surgeon. Medtronic was in no way part of the planning of the surgery. If you look at Exhibits 3 and 64 of the complaint, Dr. Denning mapped out this surgery a month before the plan for the surgery, a month before anyone arrived in the operating room, and he carried out that plan, he and his colleagues, after the surgery, at the time of the surgery. One last point, if I could. The allegation of information belief allegation that Medtronic performed this surgery, a Medtronic clinical specialist, is refuted by the federal complaint at pages 28 and 9, lines 23 and 24 on page 8, lines 18 and 19 on page 9, where the plaintiffs state, quote, "It is unknown if a Medtronic clinical specialist was present." So the federal complaint is at odds with the state court complaint. There is no factual basis for a Medtronic representative performing substitute surgery.
And I'll extend, I guess, because your comments have made me curious. I don't understand why any of those potential factual issues are relevant to us here, because it seems like we're on a 12B6. You kind of urge a 12B6 failure to state a claim in your supplemental. We take all the factual allegations in the complaint, even the information on belief, as true. So why, you're pointing out some things that may be very valid for summary judgment or merits, but why is this relevant to our analysis?
Because under the Cullen case, she has to have some factual basis for these allegations. She can't just state conclusions. And under that standard, this court has the power to dismiss this complaint. It's an argument we raised below in our motion to dismiss, albeit not reached. Res judicata, the motion was granted on res judicata, but this court, on its de novo review, has in its ability to look for some factual basis for the allegations she makes, and there are none.
Thank you, Mr. King.
Thank you.
As far as factual allegations, the standard the Supreme Court has come up with, U.S. Supreme Court and Arizona has now followed, is there need to be plausible allegations. The allegations here are horrendous, complex. They discuss a collusive effort to commit what amounts to medical battery and a series of misrepresentations. They explain that Medtronic personnel were in the surgical procedure areas and were assisting. Whether or not those are to be believed ultimately or not, or can be proved ultimately or not, is not the issue before the court. They are certainly plausible allegations. They're made in rich detail and provide enough basis to go forward with the case. When my clients, I hope, there's a remand that they return to the trial court and get a chance to go forward, I will certainly assist them in drafting a complaint that anybody would be proud to read, and then we'll try to get somebody in there to help prove it. But at this point, those allegations are supposed to be believed, and they are certainly plausible. It's a difficult story to read. If they are correct, they are the victims of some pretty unpleasant activities, and followed by some unpleasant cover-ups of some of those activities, including falsification of documents. But they deserve an opportunity to at least try to prove them.
Well, to get to the merits, we're going to have to resolve the jurisdictional issues, obviously,
yes,
as we talked about. Can you respond to Medtronic's counsel's argument about the distinction between the holding company, or his argument that this case is different than the other Medtronic cases in Arizona because they've only sued the holding company?
Well, the Joneses tried to identify, name, and serve the correct Medtronic entity. It was a lot like one of these Russian nesting dolls, doll within a doll within a doll, to try to figure it out. So they, as far as they were able to, they sued and served what appeared to be the Medtronic entity that was correctly involved in the case. In the federal district court,
They get it right.
I think they did, Your Honor. In the federal district court, it's sort of just Medtronic is hanging out there, and here it's this Medtronic PLC. But they identified and named variations on the Medtronic entity. I believe they captured the essence that's Medtronic, whether it's Medtronic PLC or one of the other ones that they identified in the complaint, as working together. So I think they got it. If not, that can be certainly unraveled more easily at the Superior Court than here at this stage in the proceedings. The other thing that I think everybody was complaining about was the joint venture thing. Joint venture is something that pops into lawyers' minds and judges' minds when you hear about people cooperating and doing things together. The average person, wouldn't have a clue. And the original formulation was joint adventurer, which is even more archaic and hard for their everyday people to deal with. But when I read the complaint the first time, I said to myself, this is a joint venture. They're alleging a conspiracy, a collaboration. Everybody's working together for a common goal. They're getting paid for what they're doing. So it has all the elements of joint venture in there without the actual name. But I think under Rule 1 and under general principles of jurisprudence, you're supposed to look to see, well, what are they actually alleging? What is the essence here? And the essence is the joint venture. It matters for jurisdiction because if you have jurisdiction over one member of a joint venture, you've got jurisdiction over all of them. And here, if you got jurisdiction over Dr. Denning and the Dallas Neuro people, then you've got jurisdiction over the people that were assisting him and assisting them in what they were doing as far as the medical battery. So it's a two-step process. You get personal jurisdiction over Dr. Denning and the folks immediately working with him. And then if there is a joint venture, if we have alleged enough, then we have the opportunity to prove that at the Superior Court, that there are indeed these connections here that were alleged in detail in the complaint. My clients refer to this as a conspiracy more than anything else. And that's probably a layperson's view of it. But this isn't the grassy knoll. This isn't crazy stuff. This is detailed. This is what happened. This is what they told me. This is what they covered up. Page and verse, chapter and verse of everything they went through. It's there. And I hope that they get the chance to go to the Superior Court and with a redrafted, better complaint and prove the allegations that they have made, because they are important allegations. And what happened to the Joneses was simply terrible.
Could you respond also to the arguments regarding claim preclusion? As it does seem like the Ninth Circuit found as a matter of law almost that there was not a properly pled fraud claim in this federal complaint, and at least by reference to the state complaint as well. So help me find a way, or help me find a way around that I don't want to say, it's not law of the case, but at least that precedent.
Well, the Latin phrase came in my mind when my colleague was talking, tabula rasa, which is really what you've got here as far as the district court. You've got a blank slate. There's no complaint, really, when you get right down to it. There's going to be a complaint that's going to be refiled, and we'll have a smorgasbord or a selection of allegations that they're making. I don't think the Ninth Circuit...
And maybe it's something that's obvious to everyone and not to me. Why would it, even if we send it back, why would you be allowed to refile an amended complaint at this point?
Well, there'll be an amended complaint because the Ninth Circuit said...
Oh, in the district court.
The district court.
Okay, yes.
Yeah, in the state court, I would pray that it'd be nice if you could tell the judge to let her file an amended complaint, but maybe you can't do that. But it would be sensible on the part of the Superior Court judge to give them leave to file an amended complaint to straighten out all these difficulties, to make sure everything is played clearly and in numbered paragraphs and set up in a proper lawyerly kind of way. It would make the case far more efficient to handle. But in the federal district court, there's really no complaint when you get right down to it. So there's certain things that the Ninth Circuit said that she could amend her complaint to put, and I think they left the door open that if she wants to try again on certain things, and if you didn't allege facts the first time around on this point, well, I don't know why she couldn't try at least to allege facts more clearly on any point. Other than the one or two that were expressly shot down by the Ninth Circuit.
One of those was the fraud claims.
Well, fraud by omission claim, they say it's expressly exempted. You're done. I'm sorry, that's it. You can't do anything with that. But there may be other claims that they can allege in the federal district court that the Ninth Circuit didn't mention that, taking a fresh look at it, they may be able to allege. I just don't know at this stage, Your Honor.
Okay.
I'm sure you've gotten bored listening to me. Are there any questions?
I don't think so. Thank you, Mr. Abney.
Thank you very much for your time. I appreciate it.
Counsel, thank you very much for the excellent briefing, argument here today. We thank you for the supplemental briefing. It was very helpful. We'll take the matter under advisement now, and we will issue a written order in due course. Thank you. The court stands adjourned.